We have a quorum. The assigned protest number is 2024-65. The property location is Fort Clark Springs Association. This meeting has begun. Do you guys want to introduce yourselves, or?
I'm Wanda Sylvie.
Linda O'Brien?
Good evening.
There we go. Mr. Welly, you want to introduce yourself?
John Welly,
Thank you.
representing Fort Clark.
Okay. Okay, the ARB board is trained to perform an independent review of your protest. We have not communicated with anyone about this protest, and we have signed affidavits to that effect. Our job is to weigh the preponderance of evidence provided by property owners and the appraisal district. The board will come to a fair and impartial conclusion. You may complete a survey regarding your experience today. The survey is voluntary. You also have the right to appeal the decision. Appeal information will be provided upon request. You will be given 15 minutes to present your evidence. He will be given 15 minutes to present his evidence. Okay. Have we gotten everything we need in the way of written or electronic material? We're all here,
Yeah.
okay.
The forms are correct.
No one here has a license or certification as a Texas appraiser?
Other than myself, right? So
Who is the first to present?
traditionally, it's them, and I welcome them to the first.
May I ask a question?
Sure.
You said that we have a time limit of 15 minutes. I think I can get this done in 15 minutes, but I would ask maybe for some leniency there, just from the perspective of, I don't know how many people you'll have coming here protesting over a dozen properties at one time, but I would assume that that's fairly rare.
Well, we just had a meeting with someone who had like $40 million worth of property, and we did it in 15 minutes. So
I'll try to say.
I understand your concern, and we will be reasonable, but we're not going to be here for 4 hours.
Sure, I don't think it is.
Okay, all right, so you're going to go first.
Yes, I'm.
Fine, go ahead.
Okay. Thank you all for having me today. I'm here today as a representative of Fort Clark Springs Association to protest tax valuations on select common property based on Texas Tax Code Section 23.18, property owned by a nonprofit homeowners organization for the benefit of its members. I'll begin with walking you through Section 23.18 to show you how it applies to Fort Clark Springs Association. 23.18 Section A reads, because many residential subdivisions are developed on the basis of a nonprofit corporation or association maintaining nominal ownership to property such as swimming pools, parks, meeting halls, parking lots, tennis courts, or other similar property that is held for the use, benefit, and enjoyment of its members of the organization, that nominally owned property is to be appraised as provided by this section on the basis of a nominal value to avoid double taxation on the property that would result from taxation on the basis of market value of both the property and of the organization and the resident units or lots of the members of the organization whose property values are enhanced by the right to use the organization's property. So let's break that down. What is the purpose of Subpart A? Subpart A is a public policy justification for the legislation. In other words, the concepts discussed in Subpart A are not a requirement that have to be demonstrated by a taxpayer before the Section 23.18 applies. It is the legislator describing to us the taxpayer and others involved in property taxes and why this section changes the way certain property is taxed for that purpose. What are the main reasons expressed in Subpart A? To avoid double taxation of property that would result from taxation on the basis of market value of both property of the organization and of the residential units or lots or members of the organization. So right out of the box, we are told what needs to be avoided: double taxation. Second, the most important part of Subpart A is the circumstances that the legislator feels that are in danger of this double taxation. There are two main conditions that the legislator we're concerned might happen. When the association maintains nominal ownership to such property as swimming pools, parks, meeting halls, parking lots, tennis courts, and other similar property held for the use, benefit, and enjoyment of the members of the organization. And I want to make a note here. Mr. Tate is going to tell you that we own undeveloped lots that are platted within the association. There's no reference to that in the law. It does not apply. This is not about how many lots that we own. This is about nominal owned property, which is the amenities, specifically things such as, or common to, swimming pools, parks, golf courses, parking lots, tennis courts, and all the things that the amenities that the members of the board enjoy. In this context, what is meant by the term nominal, which will be another one of Mr. Tate's arguments, is the Latin root, the word nom, which means in name. So in this context, the word nominal means in name only. It does not mean that the association has to own less than a majority of the lots, or that the swimming pool, parks, trails, meeting halls, airport, etc. cannot be owned by the association. What is important is why those properties are owned and how do we know that? By the very end of subpart 8 when it states as follows, where the owner's values are enhanced by the right to use the organization's property. So clearly what the legislator should like to avoid is that swimming pools, meeting areas, and etc. being taxed at full value, and then that value also being picked up on the lot or the homeowner's side value each year is to be avoided. So what is actually required of Section 23.18 to apply? Section 23.18b covers this. First, there must be property owned. There is no question here that the amenities such as the pool, airport, and etc. are all owned by the association. Second, the owning of the organization qualifies as a nonprofit homeowners organization under this section. So now we have to jump to subpart D, which states an organization qualifies as a nonprofit homeowners organization under this section if, number one, it's engaged in residential real estate management. We control the selling of all the real estate owned by the Fort. We also maintain all of the real estate transactions and all of the transfers that have happened. Check. Number two, it is organized and operated to care for the amenities held for the benefit of the owners on the Fort. While we can all in this room agree that there are improvements to be made, and that is why we are here, our entire staff and our overall management structure is providing recreational experience for our members. We also maintain, to the best of our ability with the limited funds accessible to us, the historical structures, the amenities of the Fort. Examples, we had a request from you, Linda, the other day for windows in the commissary, I believe. And that was paid for. There's a rock wall being built at the stables right now, or repaired. That was paid for out of funds of Fort Clark Springs. 60%, so check on number two. Number three, 60% or more of the gross income comes from membership dues, fees, or assessments from the owners in Kinney County. We don't even talk about it. It's absolutely correct. Number four, 90% or more of the association's expenditures are made for the care and maintenance of the association's property and held for the benefit of the owners of the Fort. Absolutely, check. We qualify for that. All of our money goes to the Fort. I think outside of 1% of all the money that we have might go to scholarships and things for Kinney County. Owners own rights to use and enjoyment of the amenities. And in our revised Declaration of Protected Covenants, in reference to Article 3, intended use of common property on page 3 of 16, which states, 1, common property shall be used primarily for recreational purposes in accordance with the association's governing documents and recorded plats. Each member shall be entitled and subject to rules and regulations that the board may take to all permitted uses of the common property, but the foregoing shall not be construed to impair, diminish, or restrict the right of the association to levy and collect dues and assessments, to make rules and regulations, and to change other appropriate fees for facilities, equipment, and similar items. Part 8, duration of the declaration. With respect to common property, on page 13 of 16, which states, this declaration shall run with the land and will inure to the benefit and enforceable to the association a lot owner to remain in effect for 20 years. So essentially that's saying that all your rights are there for you to enjoy all of the property, with all the amenities within the association through the Declaration of Protected Restrictions. Net earnings of the organization, so check on number 5. Number 6, net earnings of the organization do not inure, and inure means to vest, in any member or individual other than by providing care and maintenance of the amenities. We all know that nobody benefits from anything going on in the Fort other than its members. All of its money gets spent for the members. if we had any excess money at the end of the year for a profit per se, all that money would still go back into the coffers for the members. We could use 5 or 6 million more if anybody has a donor. We are recognized, number 7, we are recognized as a nonprofit, Texas nonprofit, and this code that I'm about to refer to, number 7 section here, this code reflects 23.18. They're essentially a mirror of each other. Number 7 is the organization qualifies for taxation under section 528 IRS code entitled Certain Homeowners Associations. A homeowners association as defined in subsection C shall be subject to taxation under this subtitle only to the extent provided in this section. A homeowners association shall be considered an organization exempt from income taxes for the purpose of any law which refers to organizations exempt from income taxes, meaning nonprofit entities. Check. We absolutely qualify as a Texas nonprofit. Now that we've concluded that FCSA meets all the requirements, all 7 requirements of a nonprofit HOA under the tax code, let's jump back to section 23.18, section B. Subpart 1. The property held for the use and benefit and enjoyment of all members of the organization equally. That is the definition of our existence. That is the only reason we have a board, that we have a general manager. That is the reason. It is for the benefit of and enjoyment of all members of the organization equally. Okay? Subpart 2. Each member owns a right or easement. Mr. Tate's going to say that we don't. Each member owns a right, easement, license, or other non-revocable right to use and enjoy the property owned by the fort. Do you have the form, Susan? When you buy a piece of property on the fort, which some of y'all have in the past, you get this piece of paper. And it has your signature, the person transferring the property, and it has your membership ID. This is not revocable. This follows the law. If you own a piece of property in the fort, which many people do, they owe $20,000 in back money that they have not paid us over the course of 15, 20 years. They still can come in and out of that gate whenever they please. It is against the law for us to revoke their ability from coming into that fort because of some wrong that they did, other than if their property gets taken from them through normal Texas law, foreclosure proceedings, whatever the case may be. Okay? So, subpart 3, each member's rights to use and enjoyment of amenities are appurtenant, means while technically detachable, is so fundamental to something else that it should be regarded as part of a whole, to an integral part of the taxable real property. The declaration says this: the declaration shall run with the land and will inure the benefit of the and be enforceable to the association or lot owner and remain in effect for 20 years. In summary, the only reason that the association exists is to provide a upkeep on all of the property nominally owned by the association and to manage that said property equally and with a non-revocable easement or license to access it. I don't even know why I feel like that needs to be defined, but I know that it's coming, that there's going to be an argument that somehow that doesn't happen. And if there's some part of this where that I'm wrong and now can be proven wrong, I'd like to hear that. But the only reason that we exist is to do this. And if you have a question for me, it might be just thinking ahead here, is what should be the value of these amenities? Every amenity should be valued at about $100. Because, and Mr. Tate's going to say, well, I don't set the market value, but I'll challenge anybody in here that's ever owned a house. If you own a house and it's $100,000, that's what you paid for it. And you came down and you saw Mr. Tate, and you said, Mr. Tate, I paid $100,000 for this. And he says, okay, well, I'm going to value it at $60,000, whatever he does, as far as his appraisal, and that's how it's on your tax rolls. But in a couple of years, you decide to go down the road and you decide, I'm going to sell my house. And you sell it for $300,000. And you're able to sell it because they have access to a pool, a golf course, amenities. They have all these trails to walk on. They have all this access. They don't want to buy that house in Bracketville. They want to buy it on the fort. And they're willing to pay $300,000 to get that house. Do you sell it? Do you think their taxes are going to be $60,000? No. Because in my own personal protest, he used a listing price against us in order to dictate where our value of our property was supposed to be. So when you sell your home, that is how he sets the price. It is not set by some out of the air, whatever. The buyer sets the market within Kinney County. If you had a flood of people come from California that were willing to pay $1 million for those homes on the fort because of its amenities, your taxes would go up. And by definition, that means he does not set the tax rate, the buyer does. And that is why it's absorbed already in your dues that you pay, or when you buy your home, and it's taxed. It's already absorbed in there, and it 100% qualifies as double taxation is what the fort is being subject to. Every member of the fort already pays this tax, and then your dues pay for it again. And I hope that y'all can be impartial, and if I've been wrong about something, I'm more than happy to stand up. Thank you very much.
Okay, it's minute 32. You want to start your 15 minutes?
Okay. To me, we can keep this very simple.
Excuse me,
Go ahead, sorry.
gotta reset it, sorry.
No problem.
Yeah, okay. Go ahead, sir.
The presentation of the tax code, and that's the basis under which they're protesting. So that's the only reference that we have for this protest, section 2318. And most of it's been read. But again, section A, and I think that everything hinges on section A, and then we'll look at other issues further down. Again, and I think you all have a copy of the code in your packet. If you'd like to look at that. Again, it says, property owned by a nonprofit homeowners organization for the benefit of its members, section A, because many residential subdivisions are developed on the basis of a nonprofit corporation or association maintaining ownership to property such as swimming pools, or nominal ownership, sorry, I didn't go over that word, nominal ownership, such as swimming pools, parks, meeting halls, parking lots, tennis courts, other similar properties that is held for the use, benefit, and enjoyment of the members of the organization. That nominally owned property, again, second time the word nominally owned or phrase property is to be appraised as provided by this section on the basis of nominal value. So we can't get to nominal value without having nominal ownership. So it's my contention, based on the ownership of the fort, and if you'll go through your packet, their own protest lists more than 70 properties which they're protesting the value of. That it's my contention that the fort does not hold a nominal ownership of the organization. They own the vast majority of the organization. If we break down on the lots themselves, they own, in my sheet, or in there, I state 51%. Actually, it's greater than 51% of the lots are owned by the fort. But that doesn't include the rest of the property of the fort. The fort owns all the acreage outside the subdivisions where lots are privately owned. They own all the green areas within those subdivisions. They own all the buildings that exist on the fort that no member has ownership to. So when you begin to accumulate everything that the fort owns on a percentage basis, I'm not sure because I'm not pushed the numbers that far, but they own the vast majority of the organization, not a nominal portion of it. And to be able to get to a nominal appraisal on those properties, the ownership, as the code states in two places, it has to be a nominal ownership. Doing some research, the homeowners associations that exist in the state that do qualify under this, they generally own like 1 or 2% of the total property within that subdivision or that association, not the majority of it. So simply on that basis, they do not qualify under the code itself. It states very clearly, nominal ownership. They own the vast majority of the fort, period. So therefore, I can't give them nominal value because it's theirs. It's on the recorded deeds at the courthouse. Then, in my second point, that the fort doesn't qualify due to the fact that Fort Clark does not allow equal access for all members to all properties it holds. The 400 acres. There is no access to all members equal. That's just one example. Airport, golf course, hotel, commissary, RV park, camping world. I can go on. We don't all, as members, have equal access to all those properties that are owned by the fort, which the code states that we have to have that equal access for all the property. And then the property is held for use, benefit, and enjoyment of all members of the organization equally. The hotel is open to the public. The golf course is open to the public. The RV park is open to the public. Yes, we do have access to that, but it's not for benefit of the members directly. There are other steps that one would have to go through to be able to access. And then on the notion of owning an easement and a license or other non-revocable right to use and enjoy on an equal basis of all properties held by the organization. In our deeds, in the deeds, in any recorded deed, there's no direct link that shows there's an irrevocable access. And my contention would be, as an example, would be the hunting program. During certain times of the year, and I know it states there's rules and regulations that can be implemented, but there's times of the year where the membership's access to all of the property equally is denied because there are being hunts sold to outside people for profit. Then if we want to get off into the financial, I would ask they open their books up so we could see that to see if 60% of the income from the fort comes, as it states, from owners of residential or of residence or residential lots. So 60% of the fort's income would have to come exclusively from owners of residence or residential lots. That would exclude the hotel, the RV park, the golf course, any other income producing, whether they lease something to some organization, where there again, if a property is leased to an organization like the Art Center, we don't have equal access to those centers. The community council has exclusive use to some buildings. We as members don't have equal access to all of those places upon the fort. So there's all those issues. And then my final point would be, we don't appraise the properties as though the amenities add value to the individual homes. So the issue here is the value in this protest is not going to go away. The value that exists on the fort is there. At this moment in time, we assess the fort with that value. If you are to find in favor of the fort, and we have to appraise everything they own at a nominal value, that value is going to have to get shifted somewhere else because it's not going away. So at that point, and we would lose that value for our taxing entities for this year. I would seek legal relief in future to come back and recoup that value for the entities at a later date. But in 25, then there would be an additional appraisal value added to each one of the lots on the fort and residence owned by individuals based on the value lost from the assessments to the fort. Therefore, all the appraised values would go up on the fort to acknowledge the value that they say is to be removed from the fort at this time. And just one other clarification, I do not set tax rates. I have nothing to do with tax rates. I don't set a dollar amount on the taxes that are set. Those are set by the taxing entities. What we do here is we appraise. And at this moment in time, there is no home on the fort that has included appraisal value because it sits on the fort. What the fort offers for those homes are for the amenities of the individual. But as for property value, it adds nothing to the individual homes on the fort for property tax purpose appraisal. And if you have any questions, and I mean, to me, it's very clear. They own more than a nominal amount, period. That should disqualify them from the nominal appraisal. If they were to own 1 or 2%, fine, but they own 70, 80, maybe even more percent of the total of the fort. We don't, as members, have equal access to all the properties on the fort because many of those properties are for exclusive use for other people outside the fort. And therefore, just on those two bases, and like I said, to get into the financials, we have to look at their financial records. I don't believe that they have 60% of their income that comes from residents and residential lots because a vast majority of their income comes from the hotel, the RV park, their hunt, and outside income.
Golf course.
Golf course. So that's where I'm at on it.
Just as he did mention that in his
While he's reading that, Mr. Worley, do you have a number that you feel is the appropriate opinion of value for the fort?
I'd have to look at the list. That would, I think in order for there to be an accurate judgment, and some of Mr. Tate's points are valid in the sense like the 400. I don't know that that's on the list. I can't remember. And of course, the association has to do that for safety reasons. But, and I don't know that we were even protesting that. Anybody use that as an example. I think in order to come up with a number, we would have to probably sit down and figure that out as a group, I'm assuming. But like I said, every single amenity that you can come up with in your mind on the fort needs to be valued about $100 each. It needs to be assigned a nominal value.
So I can assume that the number that you have.
I'm not moving off of my number.
I'm going there. Hang on.
we don't know what the number is.
Yeah, we don't know what the number is. Normally, I would ask you.
Well-
I would ask you what your opinion of that
This
is.
issue, it's not an issue, at this point, it's not an issue about a number. It's about whether they even meet the requirements of the code.
Right,
which
I
they're
understand.
protesting.
I understand.
So, at this point, we can't even deal with a number.
Okay.
Because what we're asking you is to make a determination of whether they even qualify under the property tax code. It's my sense that they do not qualify under the guise that they own more than a nominal amount of property. I mean, it's very clear from the very beginning, the outset of section 2318, which is under what they are protesting, they own more than a nominal amount.
Since Mr. Tate is not answering the question and he's expanding on the question, could I also be given the same latitude?
Let him finish.
So that's my principal contention. They don't qualify for this under the section from that standpoint. Secondly, because I am a member over there, I know that we as members don't have access to all properties equally. Period. Absolutely not. We don't. And that's one of the conditions. It says, section B, number 1, the property is held for the use, benefit, and enjoyment of all members of the organization equally. The moment they have leased out a portion of that organization property to some private organization or some other 501c3, it no longer belongs to the rest of us. We don't have access to that.
Excuse me. We do not need conversation from the audience. You're welcome to sit there, but do not interrupt my smart remarks. This is a public Texas hearing.
Correct.
Disruption is against the law. It's a Class B misdemeanor. No discussion. Thank you. I'm sorry, Mr. Chair.
So,
This is a simple question, so I hope it's not too far down the line. If you are a member and you're not in good standing at the fort, you're restricted from using.
I don't know that.
Is that an issue here?
It possibly could be, but I don't know if they restrict.
Excuse me. May I reset it for another 15 minutes? I know we've already passed our 15 and 15. Do you want to go ahead?
No, I think are we prepared to make a decision? Or not? Do you want a more discussion? I mean, we can sit here and go round.
Well, I realize that, but I'm just asking. Question.
No, I don't think.
May I be given the latitude since you're asking a simple question the same as me? I was very narrow in my answer. He expanded on that answer, on that. May I expand for 30 seconds?
Sure.
Please read this where it says, the association maintain nominal ownership to property, and it gives examples of that property. The examples are swimming pools, parks, meeting halls, parking lots, tennis courts, or other similar property is held for the use, benefit, and enjoyment of the members. It is not talking about how much land we own. We don't own them. We only own them in name only. He's applying this towards a meaning, a dictionary meaning of value in money. It's not talking about value in money. It's talking about value in ownership. We hold these properties in name only for the use and benefit of its members. It is not about how much. It is not about the percentage of which we own. We own them. Of course, we own all of them. Tell me another HOA in the state of Texas that owns as much as Fort Clark does. There's not one that exists. That's what makes it so awesome. That's what makes it have so much more value, and that's why it's so much more susceptible to double taxation than any other HOA that all they have is a front office and a swimming pool. That's it. We have so much more than that to offer, which makes it so much easier for us to be double taxed. This is not about how much property we own. We only own that in name only. It goes from one board to the next, and it belongs to the members.
Okay, let's stop.
Okay.
I just say he made my point for me. They're different. Every other homeowner association owns a nominal amount of property by which they can be appraised at a nominal value. This is not the case here. They don't own a nominal amount. And on the deed, it is owned by Fort Clark Springs Association, not the members, period.
Okay. Are we prepared to make a decision? You guys have any more questions? Wanda?
No. No, but I want to make a statement.
Okay.
I'm reading what Mr. Wiley gave us. I'm reading what the tax office says. And they either basically read the same with the points. But under 23.18, excuse me, both paperwork, and I made some notes, owned by non-profit homeowners association. We've already established, this been said on tape, the golf course is used by public or a tournament by the public, they make money. The swimming pool, they make money. The hotel, they make money. You run the NCO club, they make money. They used to, I don't know what's going on there now, but the Delt Center. So as far as what I'm reading, in that first paragraph, property owned by nonprofit owners, so they do not qualify under the word equally if they're making profit in these areas, the RV, the camping world, like everything's been said here, they're making money. So no, I can't digest the word nonprofit or homeowners association.
If you'll ask me that question, I can answer.
Well, I think we've had enough discussion. I'm sorry, you know. At this point, I'd like to have someone make a motion to determine what is the exact value and announcing that value.
I don't think we're ready to make a value.
Don't we have a value?
No, it's not a value, it's whether they qualify for.
It's a, okay.
The question is, they want to
I thought you had a value
No.
and you wanted to stick with it.
No, this whole thing is about whether they even qualify.
qualify or not, that's the question.
Okay.
It's
All
my,
right, so the question is, does the ARB board want to decide whether they qualify or not? All those in favor that they do qualify? All those in favor they do not qualify? I think we have an answer. According to this
Did you
ARB
state
board,
that verbally?
well, we've already had a vote and the ARB board has decided they do not qualify.
by show of hands.
Yes, by a show of hands.
Unanimous.
Yep. So you know what the final decision is. And, anything else anybody want to say? Thank you
Thank you.
for your time and your participation here. I would like to make a motion that we adjourn this meeting.
So moved.
All in favor? The meeting has been adjourned at 1:08.
Thank you very much.
Thank you. Thank you.
Run.